main specialism as a wills and probate specialist really relates to sort of life and death planning. But that's just as important in your business life as it is in your personal life. It's traditionally a very slow-paced area of law, so Brexit isn't going to affect my side of things for much longer, but there is something I will touch on at the end that might perhaps be relevant. I think the biggest point I want you to take away, it's a Benjamin Franklin quote, which is, if you fail to plan, you plan to fail, and that really does happen in businesses. Your business probably started as your personal light bulb moment. But somewhere along the line, your commitment to it is going to come to an end. And planning for that exit should be a fundamental part of your strategy from the beginning. You need to consider it carefully, you need to plan, decide what's going to happen. But experience suggests that's not what we do. People who go into business like the cut and thrust of the trading and not the paperwork. So they don't plan ahead. We all hope that we're going to live into our gentle retirement, but unfortunately for some of us that's not what happens. So we don't plan, we die in post, and the worst happens. So what I want to look at today is how we make that happen in the nicest possible way that we can manage. It does make a difference whether you're a limited company or a partnership, but ultimately, you know, this is what we want to achieve in the best possible way. So, you're a limited company. They often start quickly. You troop along to your accountant or your lawyer and you say, I need a company. And they pull you something off the shelf. But those companies come with standard form documents attached. And how many of you actually read those, if that's your chosen corporate vehicle? We don't read them. It's an easy way of setting up a business, and I know it is because I've done it, but I will confess I have not read those articles because right now they don't affect me. I'm a sole shareholder and a sole director, so it doesn't matter. If I die, my value in that business is going to pass according to what I want to happen. But what if you're one of 3 directors? You've planned ahead, your business is successful, you can see that exit on the horizon, so you think, right, okay, we'll go and get some other investment. We'll bring in some other people that will continue the business after I've left. So you've diluted your control and ownership. But time moves on, and unfortunately the worst happens to you, but you haven't planned ahead. You haven't thought about it. So you never got round to actually amending the articles. You didn't do your shareholders agreement, which we'll come on to in a minute. Nor did you look at a cross-option agreement, which might have controlled things to an extent. And what you've ended up with is a set of articles that probably say something like that. Why on earth should your new directors have your wife, children, whoever, that you've left the shares to in your will, in the business with them? They've probably not been involved. So you sort of begin to spot a bit of a conflict. Your executors in your carefully crafted will have to hope that your directors that you share your business with are understanding that there is a mechanism in place. But they probably won't want to share control of the business with somebody they've never met. The articles give them this absolute discretion. So what you really need to do to avoid a lengthy, complicated and possibly difficult process of negotiation is sit down, look at the articles, get them amended. This is all part of the administrative stuff of your business. It would have been better to think about your options first rather than leaving a problem for your family and your directors if you die in post. At the very least, have the conversation. Have one of these. Think about it, talk about it. If you get around to having a conversation about the articles, move on the next natural step. But they're like every other form of legal paperwork. We all go, yeah, really ought to do that, but that's not what we do. And I think that the biggest thing I want to put across to you all from today is at least start to think about it. You know, we go into business, we sit together. It's all very well sitting and having a drink with the guys you've gone into business with. It's amenable, it's friendly, there aren't any difficulties. Shareholders' agreements come into their own at those moments of crisis. When you've had that one final row in the car park about where the business is going, or when there's a situation because your executors are trying to negotiate. If the shareholders agreement says what should happen, it makes life so much easier for everybody. I dealt with a client recently where I was talking to him about his will, but naturally we moved on to talk about other things. And I said to him, do you have a shareholders agreement? And he went, well, sort of. When we started the business 18 years ago, we sort of sat down and literally scribbled something on the back of a fag packet, but it's all right, we've never fallen out. Well, not yet, but what if they do? You know, or if he dies while he's still owning his shares. You know, I could potentially see his widow having to fight for her future financial well-being with a co-director who'll go, well, that's not what we agreed. At the very time when the business is in crisis because it's lost a key player and her life's in crisis. What happens to your business shares when you die? You've had your conversation, you've put your articles in place, you've got your shareholders agreement, but then one of your directors dies suddenly. It's depressing, but none of us is immortal. The right to those shares is inherited, either by the beneficiaries of the will or under intestacy if you never got around to doing that other bit of legal paperwork. The executors deal with the estate, and at some point in that process, those shares are going to be transferred according to the terms of the will. You probably have something like that in the will, which is okay in some cases. If Millicent works in the business, she's worked hard, she's contributed, then sure, give her the shares, give her the involvement in the business. The executors transfer the shares to her, things move on, business success continues. But that's perhaps not what might be suitable for the business. It's almost certainly what's in your will, because you've got children and you want to treat them equally. But that might not be what works. You know, if one of those children is the son who wants to go and wander the world till he's 30 and find his way, why on earth give him some form of influence in your business? What he really wants is the money so he can go travelling. So think about it. Think about a mechanism to actually disentangle the business from your family needs. So obvious conflicts like that lead us on to share ownership issues on death. Another bit of paperwork. I'm all about paperwork. I'm a wills and probate lawyer, that's what we do. Cross-option agreement. Again, by negotiation. You're all still alive, you're all still talking. You can put and call options in it, so that actually you have something in place, some form of mechanism to allow either your executors to sell back the shares or your co-shareholder directors to buy in the interest. So it puts the value back into the estate, lets the business carry on, creates divergent interests, and people know where they're going in life. You resolve the difficulties before they actually even get going, giving the value to those that you want to give it to. Almost certainly that cross-option agreement is going to have a mechanism in that for how to value your shares. That's the critical thing. So again, you think about how you want them valued in advance. Ownership and control goes to the business, goes to the people that need to operate the business, and the value sits with your family. Okay, you're in a partnership, so what's still a business? You've probably got people in the partnership with you. Some of you will have some assets, some of you will have some skills, some of you will have the contacts. It's still, in a breakdown, or on the death of one of you, needs to be dealt with. You know, these days, if somebody's got some good contacts and you lose them, how good is that business without those contacts, without those difficulties that might arise on that loss of that individual? So again, if you're in a partnership, get your partnership deed in place. Get it agreed. Don't leave it. I dealt with an estate some months ago where a widow came to me. Her husband had been an accountant. He had dropped dead of a heart attack with a 40% interest in a partnership that had no partnership deed. He owned the freehold premises. He obviously had his stake in the business. The business didn't have a lot of cash floating about in it, because most don't. And it was complicated by the fact that she and one of the other partners couldn't actually stand each other. She had no interest in the partnership. She and the family had obviously been interested in the partnership drawings, but that was as far as it went. His capital in that business was several £100,000. And when I moved on from that firm to join Heald, they were still trying to negotiate a way through that path, because it was something that partnership had never actually considered. It was obviously going to be financially damaging. So one of you dies in post, there's going to be some damage to your business. Initially you might think, well, how is there damage to my business? We've done the paperwork, we've put everything in place, we've got the articles, we've got all the deeds, all the documents, off we go, surely. But as I've already touched on, most businesses don't hold extra cash. Why would they? Occasionally maybe if you're planning for new premises, but generally you're not going to hold that much cash. But step one, you've got to buy out the interest in that business that belonged to the guy who isn't there anymore. Somehow you're going to have to fund that. You're probably facing a loss in profit, either because you've lost a key player or because he was the one that had all the contacts and he's taken them down the road. Somehow, somewhere along the line, losing that fundamental part of the business is going to cause you a cash flow problem. You're going to have to recruit. That's not cheap. And what if he's on your financial paperwork? What if that individual was on some form of loan agreement and you now need to renegotiate it and you're not in as strong a position as you were? So, how do you deal with all of that? How do you deal with all of these things that somebody is going to have to deal with? Well, the answer is insurance. Consider it, look for it. It will help you if you have those difficulties in your business. I'm not an insurance expert, I don't even look at insurance, but I know it's out there and I know you should be looking for it to protect your business in the event of some form of emergency. So, now we move on. How many of you in this room have actually got a will? That's about average. How many of you have actually reviewed those wills in the last 5 years? That's not so good. On average, you need to get your will out of the cupboard and look at it every 5 to 7 years. Things change, finances change, positions change, families change. Get it out and look at it. It's not generally expensive or difficult. For people who run a business, your choice of your executors and trustees is absolutely critical. They are going to be the individuals responsible for dealing with both your personal and your business estate, and they need to be the right individuals. They need to be responsible, effective, think about things. That's what will happen if you don't have a will, but you do. You will after today. You'll all rush off and make one. I hope. Those executors need to control your business interests. They need to look after it, so choose them wisely. Inheritance tax is probably going to be a factor for you as well. In most cases, businesses are relievable for inheritance tax purposes, but a lot depends on putting the right plans in place. The relief, business property relief on death, is not automatic. It has to be claimed. So make sure you've got your business records up to date, make sure that they're available to your executors. For example, they would need the last 3 years of either business or partnership accounts, those sorts of things. Equally, putting a good will in place will mean that somewhere in that will you've got the right clauses. I showed you earlier a couple of sort of sample business clauses, but what I like to see is a clause that deals specifically with your business interests. It's much easier for the revenue to attach business property relief to an individual mention in your will than it is some amorphous bit of the residue of your estate where they can wriggle. And we don't want them to wriggle. We want to put them on the spot and say that bit. So make sure you've got it in there. An even better clause will have provisions in there that will allow for example, a share reorganisation of the business, or if the shares don't divide equally between the number of beneficiaries. And the other thing that you ought to go and look at your wills for is to make sure there's some business administration clauses in there, because your executors might be in post for a while. they might have to actually take some of your business decisions in the way that you might have taken them. If you tie their hands, the business could struggle a little bit. So make sure they're in there, but get it reviewed. The earliest will I ever had to deal with, 1971. It was faded, a bit dodgy around the edges, and some of the people in it had died. It had some trust provisions in it. The estate was several £1,000,000. We entered a very long, expensive and nasty period of negotiation about how that trust fund was going to be distributed because it wasn't clear. Things had moved on, circumstances had changed. If that chap had come back and reviewed his will, looked at it, talked to somebody, he'd have had A, a much more modern document, B, it would have been much more up to date, and C, I suspect something like £40,000 in legal fees might have been avoided for the cost of a probably £500 will. You know, it's. I know you'd say, well, you're a wills lawyer, you would say that, but please go and get it sorted. Okay. My area of law hasn't really been impacted by Europe, so I'm not convinced that the recent vote is going to make an awful lot of difference, at least for a prolonged period of time. There is an EU succession regulation, largely because there are all of these different countries in Europe that all have slightly different nuances in how things are inherited. But the UK has always been, particularly in European terms, very happy to allow each individual to make their own succession plans, subject to a few requirements, but on the whole, we're much more liberal than most of Europe. Much of continental Europe has what are called forced heirship rules, where you leave certain proportions of your estate to certain individuals. Equally, there are different things across Europe about how different bits of your estate can be distributed. And, as we've sort of touched on, the EU has been a move to conformity. But the regulation came in, and it affects estates of everybody who died after 17th of August 2015, except here, Ireland and Denmark, because we didn't sign up to it. So even before the vote, this was still a really grey area. But in principle, what it allowed you to do was to elect for a certain area, a certain state of law to apply to your will, so you could have a degree of certainty. So, in theory, because most of the EU countries have still signed up to this, they will still have to apply the law and the regulation as it stands. So, for example, if you have a property in France, you could still elect to have British law apply to it, to your will and the distribution of that property, and France should still apply that, because France has forced heirship rules that you will probably, as a UK citizen, want to avoid, because you may want everything to go to your wife and none to go to your children, and the French won't do that as a matter of course. You could be living in France or living here and still make that election. There are other specific things across Europe that a lot of people perhaps don't realise. We have the concept of executors here. That's not a concept that's recognised across most of Europe. So, again, if you're going to make a generic will that spreads across Europe, my advice is you have a set of executors to deal with anything in the UK and another set to deal with your foreign property, because it will allow them to deal with the estate in separate portions, which will allow them to deal with the nuances of the individual law. Ultimately, my advice would still be make a will in each jurisdiction where you have property. Take advice from a local lawyer. I have a generic knowledge of what happens in Spain, in Italy, in France, but I am not an internationally qualified lawyer, and most aren't. So go and speak to a specialist in the jurisdiction where you own the property. It will give you a bit of certainty. And I now am going to draw to a conclusion. Plan for the unexpected. Don't assume that your life will run on rails. Most don't. So get your paperwork in order. Ensure your risks. Get your will drafted. And look at your estate planning in the EU, if that affects you. And that's me.